Hello there and a very good evening to you. This is Face the Nation. I'm Sonali Vanigapaduke. We're coming to you live from Stein Studios here in Ratmalana. Now, our topic of discussion today is constitutional reform. Is it really the priority in Sri Lanka? In February 2016, Parliament was reconstituted as a constitutional assembly with all the parliamentarians coming together to draft this new constitution. A steering committee was subsequently appointed, following which 6 subcommittees were also appointed, along with a panel of experts. Subsequently, we saw 6 subcommittee reports being presented before us. And now we have with us the interim report of the steering committee. So what is this constitutional reform process all about? Let's discuss that with 3 eminent guests who are in our studios this evening. Mr. Nagananda Kodituaku, attorney at law and also a very vocal activist. Good evening and welcome.
Hello, good evening.
We are also joined by Dr. Dinesha Samararatna, attorney at law and also senior lecturer at the Faculty of Law at the University of Colombo. Good evening to you, Dr. Dinesha.
Good evening, Sonali. Thank you for having me.
Also, we are joined by Dr. Pratibha Mahanamahewa. He was a former commissioner at the Human Rights Commission of Sri Lanka, also a senior lecturer at the University of Colombo and attorney at law. Good evening and welcome to you. My first question I'd like to pose to Mr. Nagananda Kodituaku. Mr. Kodituaku, over the recent past, Sri Lanka has been seeing a lot of white-collar crime, starting from the central bank treasury bond scam to the Central Expressway scandal. How do you view constitutional reform as a priority in the list of things that the government needs to do?
This is a very important question that you raise. The fundamental reason for this situation is that the total breakdown of rule of law in this country. The judiciary is not given free hand to deal with the fraudster elements, particularly the criminal elements occupying the office in the legislature and the executive. The best example that I can place before you all is one such case that is pending in the Supreme Court. It was taken up even today. That is about the abuse of tax-free permits by the parliamentarians and almost all TNA MPs and number of cabinet ministers. I have observed the pressure comes from the executive is such. Now you can see this matter was initiated in the Supreme Court October last year. Now we are in October this year, so 2017. Initially, the Corruption Commission, I can say, it is my view, the Bribery and Corruption Commission in this country is the most corrupt institute. I say with full responsibility. And even today, when this matter was taken up, in this particular case, I have charged all 3 commissioners of the Corruption Commission, the Director of Corruption and also the Attorney General, to perform their duty as required by law. Why I say that? These 3 commissioners, their whole office, the public office, and they are independent officers, they cannot be removed unless you bring a kind of an impeachment motion against them. There is no reason for them to fall in line with any corrupt body. For example, any politicians or any minister, or even the Prime Minister or whoever. The latest issue that I wanted to put forward is about just less than a week ago. I had to charge the Prime Minister, the Attorney General, and in that particular matter, that is this something to do with this Provincial Council Amendment Bill, the way that this bill was enacted, and the Speaker. It was again a serious constitutional fraud. But I want to emphasize here, my my humble opinion is that this country will never progress unless a genuine effort is made by the lawmakers and the executive.
So are you saying that this effort is not genuine? Is that what you're saying?
Which on this constitutional proposal? Not at all. Not at all. I can say this is an effort driven by, not by the Sri Lankan government, but by foreign force. This government, on the other hand, they do not have a mandate to bring forward any of such thing. For example, this Ranil Wickremesinghe's government, they do not have a mandate to, people in this country never ask for any of such thing, a new constitution. Who wanted it? What is the purpose of this new constitution they are going to, bring about? Even the Tamil minority people, they don't want any such constitution. Tamil politicians want it. What they want is a equal right and equal protection as a the citizens of this country. That is what the Tamil people wants. But the Tamil politicians, they want devolution. It's a fact. That's true. But not the general public.
Thank you very much, Dr. Dinesha Samararatna. My next question is to you. Before us, we now have the interim report of the steering committee. What are the implications of this document, and how far should we be guided by with regard to this? And also, could you make a distinction between the reports of the subcommittee and the interim report itself?
Yeah. So Sonali, let me give you some context before I talk about the interim report itself. This process was initiated in 2016, and prior to the establishment of the Constitutional Assembly, in fact parallel to it, the Cabinet also appointed another commission or committee to consult the public on proposals for constitutional reform.
The Public Representations Committee
Yes.
on Constitutional Reform.
That's correct.
Right.
So that committee consulted the people in all 25 districts of Sri Lanka, something that has not happened in Sri Lanka's history before this. And they published their report in April 2016. The proposals have been summarized and presented by them, reflecting the diversity of opinions that people in Sri Lanka have expressed as to what a new constitution ought to look like. So the Constitutional Assembly's task, as per the motion that was presented to Parliament last year, is to present a draft constitution to Parliament. Now all MPs sit in the Constitutional Assembly, a steering committee was appointed, and the steering committee, as you said, appointed 6 subcommittees. Now the difference between the interim report and the 6 subcommittees is that the subject matter is different. So the 6 subcommittees relate to centre-periphery relations, the judiciary, fundamental rights, public finance, the public service, law and order.
Right.
Now if you look at the interim report, it begins by distinguishing between the report itself and the recommendations made in the subcommittee reports. The interim report deals with all the other subject matter that has not been dealt directly by the subcommittee. So that's the difference between the two. As far as the implications are concerned, what's anticipated next is that the Constitutional Assembly will debate the contents of these reports, and they can propose amendments to the substance in these reports, and thereafter it is for the steering committee to present a draft constitution also back again to the Constitutional Assembly. And thereafter the motion describes a procedure that has to be followed, ultimately resulting in a draft constitution, if acceptable to Parliament, being adopted by Parliament and also being adopted by the people at a referendum.
Right. Dinesh, just to make a clarification once again, something that we see when we study all these subcommittee reports on the one hand and the interim report on the other, one is not reflective of the other. So you're saying they're mutually exclusive?
Well, they are not mutually exclusive in that they speak to different issues, but the broad areas that they address are different. So for instance, the interim report does talk about the Constitutional Court, But the subcommittee report on the judiciary also talks about the constitutional report. But there were certain aspects that were specifically left to the deliberation of the steering committee, given the sensitivity attached to some of those topics, such as devolution.
All right. Thank you very much, Dr. Dinesha Samararatne. My final question in the first round is to Dr. Pratibha Mahanameheva. Dr. Mahanameheva, are you satisfied with the manner in which this constitutional reform process is taking place right now?
Not myself, the whole country, citizens. If something you are asking from me personally, but it should reflect the whole country. Now my argument is basically, this is not the way you should proceed. The way I like, basically, like 1996, how South Africa adopted their constitution. Now, first thing, even the Prime Minister, all the ministers saying, this is not the final document. This can be adopted, this can be deleted, this can be changed. But I need, even like in Nepal, some fixed draft constitution. Now all the parties proposals asked, where the United National Party proposals are not there. All the other parties, they have given their proposals. So consultative process, yes.
So you're pointing out to the fact that the interim report contains the observations of all political parties except that of the United National Party.
Yes.
And that's a concern you're raising.
That's my concern. Number two, this constitution, still we have not seen. The draft we have not seen. So the people basically started a debate. Unitary, priority to Buddhism. Those are the key areas. Now the society is speaking. This is not the way you should done. Not to divide people like that. Look here, this is the draft constitution. Then we can start the debate. So these are only committee reports or even subcommittee reports. You have to amalgamate one. Then only others also can participate. Now my argument, they visited 24, 25 districts. Whether that process, people actually came and gave their views, gave their proposals, if given, okay. But the other way around, the politicians are trying to market this with Mahanayakas. That's why they try. And politicians are saying several views with regard to unitary, federal, as well as other areas. Will people believe that? So rather than saying those things, like other countries, you must come up with a draft. Then we can debate the draft. Then we can go for a people referendum. Now this was smartly done in the 19th Amendment. In the 19th Amendment, most of the president powers, they try to transfer to Prime Minister. But what the Supreme Court said, if you want to do that, you have to go for a two-third majority as well as a referendum. So my argument behind this, certain motives are there. If they are doing honestly, genuinely, no issue. So rather than hanging with words, Parliament, discuss, as Dr. Dinesha said, right, Assembly, where is the draft one? If you give the draft one, we can start a discussion. So even the politicians made this, they say no, we can change, we can amend. Different versions are coming up. These versions may lead to a suspicion situation. So don't do that. Politicians are not honest.
Exactly.
Politicians are not honest. So therefore, people should come up, experts should come up, and they should get the leadership rather than giving this to, basically Parliament. Even I have a doubt. The way the bills passed today, what they say, what the Supreme Court say, totally different things done in the committee stages. Therefore, I can't believe this politics.
You're specifically speaking about the Provincial Council's Elections Amendment Act.
Exactly. Later we can discuss that. But this is not the debate for it. So how can we trust politicians? Now I'll tell one thing. President said in the cabinet, don't increase gas prices. So what happened finally? So the executive president is powerful, or the ministry is powerful. So these things create a lot of doubt in the society. So don't do that for the constitution.
Thank you, Dr. Mahana Meheva. Let's take in questions now. Nadeem Majid and Charita Fernando are here. Charita, let's start off with you.
Thank you, Sonali. Mr. Nagananda Kuritok, you almost condemned the passage of the Provincial Council Amendment Act.
Exactly.
So, given the feelings, the concerns over how it was passed, how confident would the citizens be with regard to a new constitution?
You mean the citizens in this country? You know, as my learned friend said, people in this country have no confidence at all in the politicians. They are, I'm very sorry to say this, absolutely corrupt. And the way this Provincial Council Amendment Bill was brought in is a disgrace to the whole on the part of the Sri Lankan nation. First they brought in the 20th Amendment. What was the purpose, objective? That was to postpone the Provincial Council election. But the Supreme Court very clearly held that affects the people's right to franchise. This is one of the sovereign rights of the people guaranteed by Article 3. And then the Supreme Court ruled that they require, in addition to two-thirds majority, a mandate, that is approval of the people. Then that bill failed. The 20th Amendment failed. Then what did they do? There was a bill by then gazetted, that is to amend the Provincial Council election system. They gazetted it, and there was no violations of any of the people's sovereign rights, so nobody bothered about it. And as my learned friend said, at the committee stage, the whole bill, they completely, originally the idea was to increase the ladies' participation at 30%.
30 amendments were introduced.
Yes, right. Originally, the purpose of the bill was to increase the, the number of the Provincial Council ladies' participation to 30%. But at the committee stage, it was completely taken away, and the new bill, that is amendment to the original law, that is the Provincial Council election law, it was amended at the committee stage. By then, where the citizens of this country stand.
Can I raise one issue? 1 minute, Naga?
Yeah.
Now the issue is this. Youth representative was there 25%.
Yeah.
Now the committee said that it's dropped. As a citizen, I can't go to the Supreme Court to challenge it.
Yeah.
With the present legal system.
Because Sri Lanka is a representative democracy. And we say on paper, once again I emphasize the fact it's only on paper. Sri Lanka is a representative democracy, and it says people are supreme and the sovereignty is in the people, which include legislative power, executive power, judicial power, franchise and fundamental rights. The parliament claimed that they are superior over the other two organs, which is rubbish. In this country, only the people are supreme over all the other organs. What they did when this bill was failed, so the constitution very clearly provides people to challenge a bill once it is placed in the order paper. Before they place the bill on the order paper, they have to gazette it at least 2 weeks prior to the place it on the order paper. So here, they deliberately avoided it, and the people never knew about these changes. In these changes, what did they introduce? They introduced this delimitation committee that will, naturally, the purpose of it is to postpone the election. You must have seen it in the media. Chairman of the Election Commission said, the election, even he cannot guarantee 2018 that he can hold this Provincial Council.
In 2000.
In 2018. So you can see how they abuse the people's sovereign rights So therefore I say on paper Sri Lanka is a representative democracy only on paper, but that is in theory, but in practice they do not pay any respect or attention to the people's sovereign rights in this country.
Mr. Koritaku, coming back to the constitutional reforms,
Yeah.
You also mentioned that there was no request for a new constitution from the citizens of Sri Lanka.
Exactly.
Right?
Yeah.
And you also mentioned that this is something that is driven by a foreign element.
Yeah.
What benefit would a foreign element have in pushing any constitutional reforms in Sri Lanka?
You know, there are a lot of foreign powers. You can see here now Sri Lanka, although we have a Sri Lankan government here, okay, but it is been, whatever the bill come forward, even this provincial council bill and even this amendment to the constitution or the new constitution, everything is being done by foreign forces. But why I say that? And the government or the citizens in this country never asked for a new constitution, whereas the destabilization of this country is always, this is what the other foreign forces wants. They don't want Sri Lanka to stand in its own as a sovereign nation. It's always better, good for them as long as they keep it under their control. That means when Sri Lanka is disintegrated, it's always easier for them to control them and have their bases and whatever they want, that the Trincomalee port is given to somebody and the Hambantota port is given to another and the Mattala airport is taken by another company and even the port city project. There's so many things comes up. When there is no unity in the government, when there is no strong establishment here, they can do anything here. That is what is being done here in this country.
Dr. Mahanamaheva, can you also elaborate a bit on, you were also not very happy about the process of reforms, how these things are brought forward.
Yeah.
Do you think at this rate a new attempt to bring a new constitution would actually lead to a situation where the government could be unseated or overthrown?
Sri Lanka Freedom Party, one slogan is there: not to abolish executive president. That is the President Representative Party. That was openly said in the media by the Sri Lanka Freedom Party leaders. On the other hand, what is the counter argument which came up by the civil society? This is where the pledge given in 2015 January, before coming to power, we should eliminate. But still, they are struggling with that. The unity should come whether it should remain or not. Now let's see this. Finally this go to a referendum. Referendum, you can't ask list of questions. No? You need a this is two symbols are there, pot and lamp. Then how many questions you have to ask? Whether you need executive presidency. No, only one question. We need a new constitution. Let's see, people voted, we new constitution. So thereafter, the content and everything goes to where? To the parliament. That's why my suspicion is there. When parliament, they honestly doing it, no issue. But even these committee reports, as earlier Dr. Dinna said, I have an issue. It can be fully changed in the committee stages, which have not only in this government, previous government also they have done. But this is extensively happening it. So we can even add post judicial review power in a bill. So that can be promoted. And then you get the vote. After getting the vote, the final thing, parliament. Parliament, they may have 2/3 majority. They can make the 2/3 majority.
How do you think the joint opposition should look at this? Do you think they should reject it outright or engage with the new reforms?
No. My
What is
argument
your
is
stand
this.
on that?
This constitution, certain things should be changed. Specifically chapter 3. Fully changed. That I agree fully. And number 2, the electoral system. So rather than a new constitution, certain things can be added certain things can be deleted. My personal argument, executive president post should remain. I'll give one example for that. Now the land powers, provincial councils. So this amendment, the promoters say one thing, because even a provincial council, it can't act independently. So it can be taken by the power with the president or the parliament. My argument is this. Article 33D in the present constitution, even in the estate case, what happened, the president is keeping whatever the seal or whatever the land donation he signed. Because of that only, that case came up. So process should be more transparent. For that, people participation should be gathered by different systems. They went, they had their workshops or seminars, and lot of proposals were taken. But they should go to more transparent level. Are people need a new constitution today, or are they suffering with cost of living? Even people suffering only, you all can take 3 meals or you can take 5 meals per day. But there are people, there are people, those who are suffering.
Not even a single meal.
Yeah.
Dr. Samaratna, now Dr. Mahanamaheva said that people need to engage in the process, right? Do you honestly think that people are really interested in bringing forward a new constitution? What is your take on that?
So before I respond to that question specifically, I must say I disagree with my colleagues on many of the ideas that they expressed. Regardless of whether politicians mean well or not, I think as citizens we need to look at the merits of what is being proposed and what is not proposed. I think that's a more healthy approach, because if you take, for instance, our post-independence political history, several themes are recurrent. One is that politicians act with their expediency in mind. In fact, if you take the 1978 Constitution and if you look at all 19 amendments, you could make that argument that these amendments were introduced in order to ensure that the party in power continue to remain in power. So you can continue with that line of argument, but I think it's more productive for citizens to look at the substance of what is being proposed and then agree or disagree, because that's what ultimately has an impact on our lives.
Dr. Samaratna, with
yes.
regard to the substance that has been proposed,
Yes.
there is some very important information that came to light this morning on our program Newsline. Attorney at Law Krishmal Varnasuriya highlighted the fact that several observations and recommendations in the report of the subcommittee on the judiciary had not found their way into the interim report
Yes.
of the steering committee. So given these little lapses, doesn't it raise suspicion in your mind regarding how genuine the not just the government but the Constitutional Assembly as a whole is regarding this entire process?
So just to reiterate, I am not making a judgment on the genuineness or the lack of it, because I think that's not possible. That's not possible at any point. But to respond to Mr. Varnasuriya's concern, as I mentioned to Sonali earlier on, the interim report is not to be read as dismissing the subcommittee reports. It's to be read alongside of the subcommittee reports. That's very clearly stated in the beginning of the interim report itself, because it says the steering committee presents these proposals in addition to what has been proposed already on certain themes that have been listed out. So that would be my response to that particular question.
And very well answered. Dr. Samaratna, I'd also like to ask you this question. It was in relation to what we were talking about before with the Provincial Council Elections Amendment Act now. There were some questions regarding the standing orders of Parliament. As a legal academic, I want to ask you, how much store should we put by the standing orders of Parliament? Do they carry any power whatsoever in governing how Parliament behaves?
Yeah. So that question actually also ties up with the concerns that were raised earlier. So this is in fact one of the reasons as to why we need a new constitution. Now the 78 constitution does not allow for judicial review of legislation. So once Parliament passes a law, that remains in our law books unless and until Parliament chooses to repeal it or replace it.
Yeah. In the current context though, if parliamentarians, even the Speaker, are in violation of the standing orders, I'm referring specifically to Standing Order 57, which says that the principle of the bill shall not be discussed, shall not be debated in committee. Now, you can't extend a one-page bill to 30 pages without discussing the principle of that bill. So I'm assuming that Standing Order 57 has very clearly been violated. In that case, when it has been violated, what action can the people take?
Under the present constitution, it is not possible to challenge it in a court of law because the constitution very clearly excludes judicial review of legislation.
Mr. Korituakwa, I'd like to come back to you in this light. You have already highlighted some glaring issues with the Constitution of 78 and subsequent amendments, specifically the 14th Amendment. Dr. Mana Maheva spoke now about the absence of the ability for the citizenry to seek post-enactment judicial review. In light of all of these concerns, don't you think that it is very important that we undertake a process of constitutional reform now to address these legal potholes?
But I can assure you one thing. The so-called proposed constitution, so as my learned friend said, there is nothing, no draft constitution put forward yet. I can assure one thing. Right now there is Article 80 and 124. There is a bar. That means the judiciary has no, jurisdiction to inquire into anything after Speaker certify the bill. That has to be removed immediately. That has to be taken away. And also, there has to be judicial review. In this country, the constitution says it's a supreme law. At the same time, there's a provision in the constitution which says whatever the law is enforced will continue to be enforced. What is the purpose of the supreme law? When you say the supreme law, when the constitution says that's a supreme law of the land, when that law comes into force, any law that inconsistent with the constitution shall be, should go, shall be repealed forthwith. But whereas in this constitution it says, the 78 constitution, it says although this becomes a supreme law of the country after the parliamentarians enact that law, it says that whatever the laws still in existence will continue to be enforced. That's no point. And judicial review, what I believe, I saw it in the Supreme Court today when the Sarathana Silva's matter was taken up. It was a very valid argument that he put forward. He said the people in this country, they were taken for right. It's a constitutional fraud. They introduced one bill and that they failed, 19th Amendment failed and the 10th Amendment failed. Then they used this Provincial Council amendment bill, and at the committee stage they brought in all these changes, that is to even to postpone the election. At that stage citizens had no say at all. So therefore now today the Attorney General argued in the courthouse after the Speaker certified the bill, so that no one can question, and it is proved, and I saw that. And if you refer to Article 77, Attorney General has nothing to do with he has no authority whatsoever to confirm or make his opinion known to the Speaker. That
it's
is
not a judicial opinion.
He can only say whether it is required 2/3 majority or not. But he cannot say it is only vested with that power is only vested with the judiciary, whether it requires a people's approval at a referendum.
But Mr. Korituakwa, in light of what you're saying, in light of these issues, in light of the corruption, in light of the legislature hijacking democratic process, don't you think that now is the time to advocate and to undertake constitutional reforms and to include the reforms that you're talking about as well? Post-enactment judicial
It's a very, very good question that you raised. That time when they called for these people's proposals, I was in London. I put forward my proposals. I asked these people who, they did not even listed the proposal that people like us put forward. So therefore I say, this is another eyewash. Okay? This is not a genuine effort. What I can tell you is that then when the people in the legislature is dishonest, right? I once again I say that when the people in the legislature and the executive are dishonest, you cannot expect anything good for the people in this country. This effort is another eyewash.
But is it practical to wait for an honest legislature in order to undertake constitutional reforms? We'll be waiting forever if that's the case.
That is why I came forward. That's what I decided. I have challenged so many cases in the Supreme Court. I found out the judges in this country, their hands are tied. And they indirectly informed me, Mr. Koditwaku, our hands are tied. So I decided to come forward for this presidential election to 2020 because I have a vision. Because I wanted to give my people their rights. I mean, these people have been taken away. Their rights have been taken away. They have been deceived by these corrupt politicians.
Thank you very much. Thank you,
that is my objective.
Koditwaku.
Yes.
Dr. Mahanamaheva, before we go in for a short commercial break.
So now, if you don't mind, I have a quick question to Dr. Mahanamaheva.
Go for
on this. In light of what Dr. Samararatna and Mr. Koditwaku were saying as well, don't you think that this is the time to undertake constitutional reforms and to fix these problems once and for all?
Now look here, 2 years and 8 months gone, or 9 months gone. So another how many years we have? So we have to delay for this. But the process already began. But my argument is this: there should be certain amendments to the Constitution. But certain provisions are there in this Constitution good for the country. So anything coming new, rather than going for a refresh one or for a new model, people should be aware. Now you said there are certain committees. You ask from any person, have you given your ideas? Have you ever know about this? Now there is one certain group, only they promote it. But there are others also. But they come to debates and they say, right, this is the thing. So you have to think a mixed one. Even when these committees are selected, even we don't know how it was selected. And the way that selections came up, I am not against that. I am telling it should be more vital if people agree and people disagree. Now look here, we have a debate here, agree and disagree. Likewise, why you fail to appoint committees like that? Now, in your debate, it's very balanced. Agreed views are there, disagreed views are there. But in the committees, that is only one way. This is my personal idea. I look, it's only one way push.
Dr. Mahanamaheva, in our present constitution, the 1978 constitution, Article 3 says, in the Republic of Sri Lanka, sovereignty is in the people and is inalienable. Sovereignty includes the powers of government, fundamental rights and the franchise. Now, if we take a look at the interim report, it says there's a general consensus that the executive presidency as it exists today be abolished. While abolishing the executive presidency, the president should be elected by parliament for a fixed term of office. Now, we're talking about separation of powers, we're talking about the executive, legislature, the judiciary. However, if there's a suggestion made that the appointment of the president is to be made through parliament, don't you think that it sort of dilutes the very concept of sovereignty? What's your take on that?
My personal view, 1978, present constitution, Article 3 should be remain as it. We don't need any amendment for that. But there are certain areas where you need amendments. Now,
like you mentioned the chapter 3, that's fundamental rights.
There are certain concerns I also have. But let me answer your question now. Let's see, we are going to fully abolish this executive president system. You and I can't decide now whether this question asked in a referendum.
But the opposing view to that would be that a public representations committee was appointed where the public's views were taken. So how do you counter that?
The issue is this. the committees can be appointed, public opinion can be taken. Thereafter, you have to start another process of debating this with a draft constitution. I mean, just wasting time debating with committee reports, because there is no use finally. This is not my version.
Dr.
These are all the government leaders. They say it. And the president said, Mama meka dekalawakkatne. So, you know, these are the things, no. Wait. Experts are doing their job very well. But whether it's linked with those who are implementing, that's my question.
Right. Dr. Dinesha, how would you respond to
Yes.
what Dr.
So
Mahanam
before I
was saying?
respond to my colleague, I also want to raise a point about what Mr. Kodituaku said about the citizens not being represented in the legislative process. I don't want to go into the merits or demerits of the recent amendment that was passed, because I need to see the amendment before I do that. But one must not forget that our elected representatives did vote for this proposed amendment. So that is how representative democracy is meant to work. Representatives of the people participate in the legislative process.
Just to quote from the Constitution itself, Article 4 says, the sovereignty of the people shall be exercised and enjoyed in the following manner. The legislative power of the people shall be exercised by Parliament, consisting of elected representatives of the people and by the people.
And then to respond to Dr. Mahanam, he was concerned about lack of consensus and lack of transparency. But earlier he mentioned the lack of disagreement. Interestingly, if you look at the interim report, there are several annexures in which political parties, the proposals made by the political parties are attached to the interim report,
Sure.
in which they present their views. And they, for instance, the Jatik Hela Urumaya is one of the parties which says the executive presidency should continue, and they disagree with what everyone else has agreed to.
As well as the SLFP.
Yes. So even in the PRC report, the Public Representations Committee report, and in the interim report, you see disagreement. And I think that is healthy, especially if we want to promote representative democracy. Because it's through agreement, disagreement and debate at all levels that we can find a document for which we can gather consensus. So I view these processes as allowing us to build consensus, because it's a staggered process. Rather than presenting one bill for which people are asked to either vote in favor or not, this process, while it looks rather confusing, it does allow for consensus building, because you can disagree, you can debate, you can support, you can not support, and then try to push your political representatives to do things differently.
But Dr. Samaratnam,
All right.
will this process...
Nadeem, I'm afraid we have to go
But,
for a short commercial break
well,
now.
can I take 1 minute?
After we come back, we'll be in discussion with these three experts on constitutional reform. With it to Sri Lanka. Stay with us.